Good morning, everyone, and welcome to IPMG's Professional Development Workshop. I'm Lana Hunt, Director of Training and Outreach with IPMG, and very excited today to have the opportunity to have a guest speaker, Cathy Boswell from Insource, who will be talking with you about preparing for Student Special Education Case Conference. Just a little bit of information before I introduce Cathy and she begins. Just a reminder that for case managers, this training has been approved for 1.5 Advocare external training credits. Case managers should submit the confirmation of attendance email that you will receive from Public Relations at IPMG per the Advocare instructions to receive your credit. If for some reason you don't receive that confirmation of attendance within 2 business days, please contact IPMG's customer service at the email listed here. And do allow for about 2 business days. We normally try to have those out by Monday following the webinar, but just allow for those 2 business days. Also, within 2 business days, all attendees and registrants will receive an email with the link to the training recording and associated materials, as well as a document with the question and answers. And that's also available on IPMG's website at go2ipmg.com, and we'll also provide a link on our social media sites as well, again, within 2 business days. We also appreciate and welcome your feedback. So once the webinar is over today, you will receive a survey. It will launch immediately after we end the presentation, and we definitely encourage you to complete that so that we can receive your thoughts and your feedback as we plan for our future professional development workshop. And with that, it is my pleasure to introduce to you today's guest speaker, Cathy Boswell. Cathy is a regional program specialist for Insource and has been for the last 10 years. As an adoptive parent of a child with disabilities, she was a foster parent for over 18 years and learned how to advocate for children with special needs through Insource. She is currently also serving as a volunteer court-appointed special advocate for foster children in Newton County. So I am, again, very pleased to introduce Cathy, and we'll turn the presentation over to her. All right, Cathy, you should be good to go.
Thank you very much. Thank you for that introduction. I appreciate it. Now if I can just get mine to cooperate. There we go. Thank you so much, Lana, for inviting me to do this presentation. I do a lot of webinars for Insource, but it's really kind of nice to have somebody else that's running the program while you present. I'm sure Lana can speak to the fact that it can be challenging to do both simultaneously. So I do appreciate, again, the offer, and I think that I've got some good information to share with you. I need to start out by doing the legal disclaimer that we provide educational information for educational purposes. We do not provide legal advice, and to help parents to understand that they certainly have the right to seek legal counsel for legal questions regarding special education issues if they feel that they need to. But we don't serve as attorneys, so we don't give legal advice. In fact, we try to make a point of not giving advice at all, because clearly, as someone that works with Insource, I don't know your child like you know your child, and so all I can do is provide some guidance in terms of the special education process. So I developed this training a number of years ago. I used to be a foster parent trainer for quite some time, and I came to recognize through that, as well as through my work with Insource, that the types of questions that parents had primarily revolved around case conference committee decisions, and also came to recognize that for many parents, attending a case conference was right up there with getting a root canal, which none of us really enjoy doing. And so thinking in terms of my own experiences as a parent of a student with a disability, and in my experiences with working with hundreds of parents over a number of years, it just seemed prudent to put together some type of presentation that we could offer to families to try to make that conference go a little better. And the key is always, of course, in preparing ahead of time. So I do want to talk a little bit about Insource, of course. Insource is Indiana's Parent Training and Information Center. The federal law, the Individuals with Disabilities Education Act, requires that all states have at least one Parent Training and Information Center. Insource serves for Indiana. And we have done so since the IDEA law went into effect. We were founded in 1975 by basically a group of parents that had children with disabilities that were wanting their children to be educated and to have that equal access that most did not have prior to that time. And of course, because PTIs are required under the federal law, there is a national network of us. So again, every state has a PTI. And our services are offered free of charge to our parents. We do these trainings and we provide assistance to parents at no charge. We are funded mostly through the Indiana Department of Education, and we do have some funding through the United States Office of Special Education. And because of that, we have to collect data when we talk with parents and share information. But a little bit about some of the ways that we try to assist parents. We do have regional offices throughout the state. Our main office is, of course, up in South Bend, but there are many of us that serve regionally. I'm in the northwest corner of Indiana, so I serve the south half of Lake County, plus Newton, Jasper, and Pulaski counties. But there are staff throughout the state. If you go to our website, insource.org, you can click on a staff map and see which Insource person covers your area. Or if you can't find that, you can shoot me an email. And I did provide my contact information at the end of this presentation. So if you need further information, please contact me. I spend a lot of time on the phone talking to parents, trying to answer questions around special education issues primarily. We do offer, of course, training courses. We do some in-person trainings. We do some webinars, such as what we're doing today. We do sometimes attend case conferences with parents. Obviously, we can't go to everyone's case conference, so we try to be a little selective, but at the same time, everybody is entitled to assistance in one form or another, and so we do try to provide support however we can. Our website offers a lot of resources and publications. If you haven't been to insource.org, again, I would strongly encourage you to go there. We also have online trainings that are available there. In fact, we recently created a video on this very same topic that I'm talking about today. So if you've got an extra 35 minutes and you want to actually kind of see this in video form, please go to our website and it's available to watch free of charge. We have the online community like everyone else. We are on Facebook. We would like for you to like us because, as I like to say, we like you. So please like us. We appreciate hearing from you. Okay. All right. I think it's always a good idea to have an idea of what you're going to be hearing about as I'm doing this presentation. We will talk about parental involvement in the special education process because parents are a very critical part of the process. Then we're going to talk a little bit about just what is a case conference. Now, that may seem silly to those of you that have been involved in the special education process for a long, long time. But what I've discovered is that sometimes just in the course of reviewing a little bit about case conferences and who does what, people find out that there were some pieces of information that they didn't have and that they didn't know. So that's why I do take the time to address a little bit information about the case conference. Then we're going to talk about specific ways in which parents can better prepare themselves to attend their child's special education case conference meeting, because it does take preparation. If you're going to do a good job and you want to be sure that you get your questions and concerns addressed, you need to be thinking about it before you go to the meeting. We'll talk briefly about good communication and
Cathy, I believe we've lost your audio. It appears that Cathy is having some difficulty, so we will just give her a minute to correct that. While she's doing that, I will go ahead and let you all know that she definitely does appreciate questions that you may have. So as she's going through her information, if you have questions, please type those in, and she'll do her best to answer those today while we're on the call. If we don't get to all of the questions, she will be able to answer those, and then we will post those along with all of the other questions. So feel free to ask. She did say that she would look at questions as she's going through the information and answer those as she is able to during the presentation. We'll also let you know that looking ahead for October, our PDW in October will focus on the request for approval process for environmental and vehicle modifications, as well as specialized medical equipment. And our Ruth Roberts, who is IPMG's administrative or executive assistant and RFA specialist, will be presenting that information. So we will be sending the registration information out very shortly, so please look for that. And Cathy, are you back with us?
Well, I'm calling in on the phone. Can you still see the presentation?
We can, yes.
Okay. I'm not quite sure why the audio went out, but hopefully my presentation will stay up there and I will simply talk into the phone. So let me go ahead and see if I can advance the slide, and hopefully we're still here. I still see, you know, that I'm up, but I just wasn't sure what you could see.
Okay. All right. If you're not able to, just let me know.
Okay. Nope. So far, so good. Okay. And then so I'm finishing up with what happens if we can't agree, because we all know that sometimes parents and schools do not agree on services for their children. So before I get too much into it, I want to talk a little bit about procedural safeguards. And that's just exactly what it sounds like. There's safeguards that are written into the law to protect the rights of parents and students. And so written consent is really important. That means that at various times in the special education process, the schools must get written consent from parents before they can do something or not do something for that parent's student. For instance, the big one is schools have to have written consent from a parent before they can proceed to do a special ed evaluation. Parent has to sign consent. Also, for the very first IEP or individualized education plan that's being written, the parent has to sign consent before the school can provide special ed services. But it's really important to understand that the written consent is only required for the very first IEP, and we'll talk about that more later. Okay. The second one is parent participation. The law references parents repeatedly throughout the entire law. Parents have a right to participate. They're equal decision makers in the process.
Okay, I hung up my phone. Sorry for the feedback. Okay, I've been reestablished with my audio again. Parents often don't understand that when they're sitting around the table with the schools, that they do have an equal say-so. The schools absolutely have the right to make suggestions, to offer services and opinions, if you will, but the parents do as well. And so when you know the time comes to make decisions, parents and schools may or may not agree, and if a parent does not agree with what the school is proposing, they do have the right to use what we call dispute resolution options to work through it. It isn't, the school doesn't make all the decisions, neither do the parents. And so the team has to come together to make those decisions. Written notice of actions proposed, basically this is, the school has to tell parents if they're proposing to do something differently with their child, the parent's child, than they would do for other students. The IEP can serve as written notice because basically the school has written out the services that they are proposing for your child. And of course, you know, parents weigh in on that as well, but you have to have that in writing. A prime example of that also is if you've requested a special education evaluation, the school has to tell you in writing within 10 school days of having received your request for a special ed evaluation whether or not they're going to evaluate your child. So again, the response has to be in writing, either yes, we will evaluate, or no, we won't, and then they have to tell you why. So written notice, in other words, the schools can't just make decisions and implement them without notifying parents. Records access, a lot of parents, I think we don't really know this, but there are school records on our children. If they're attending school, there are records somewhere. It may not be in the child's school building, but they will be somewhere in some administration building. And I encourage parents to review those records because it probably has documents that you may not have at home or maybe you've lost, but you do have the right to see those. And so you can make a request to your building principal. I prefer that you do so in writing, everything in writing. The school principal has 45 calendar days to give you access to your child's school records. Now, that will be at a building. You won't be taking that home, but you do have the right to view those. You can see them sooner if there's a case conference coming up or a due process hearing is coming up. So just remember, you can review your child's records, and especially if you're a foster parent and you don't know much about this child, or possibly an adoptive parent, really need to review those records because you won't know the educational history, most likely, of this child. The fifth procedural safeguard is confidentiality. Schools cannot release private information about your child or your family, if you will, to just anybody. There are some entities that legally they can share information with. Anyone else, the school has to get your written consent before they can share. The final safeguard is that of dispute resolution, or that's back to that what if we disagree. There are procedures in place to help parents and schools to work through their disagreements, and we'll talk about those briefly at the end. Okay, so just what is that case conference committee? Well, we know that's a big group of people. Generally, mostly they're school people, as you could imagine, but they're this group of people that have a lot of responsibilities. We will be reviewing any educational reports that have been generated. We're going to review information on the student, including grades and standardized test scores. It's our responsibility to determine eligibility for services for this student. We develop the individualized education plan if it's eligible, and then part of that is determining what services are most appropriate for the student, and basically to make any and all educational decisions on behalf of that student. And I'd like to add something in here right at this point that I think a lot of parents and schools are not aware. We all know that I read takes place in 3rd grade. And basically, if the child fails iRead and fails the remediation and the retesting, that the building principal has to hold that child back in 3rd grade. And generally, principals have the decision-making authority to retain or to promote students. If your child has an IEP, it is a case conference committee decision. And that's something that I are not.
Cathy, I believe that we've lost your audio again. I'm sorry. I do apologize for the technical glitches we're having today. That sometimes does occur when you are trying to do things online and virtually, but I'm sure we will have Cathy back in just one moment. We did have a question asking if there was any need to sign in to today's webinar, and that is not necessary. Your attendance is automatically recorded once you log in using the link to log in today, so there is no need for additional sign-in. That's automatically recorded.
Okay, I'm back.
All right, okay.
Okay. All right. I don't know why the audio keeps going out. Okay. I think I'm going to keep my phone here. All right. Can you hear me okay? Can you hear me okay?
We can hear you, yes. Yes, we can hear you now.
Okay. Yeah, I'm leaving my phone on, though. I've got it in a drawer if I need to pull it up quickly. Okay. And then we got to least restrictive setting. The concept of least restrictive environment means that to the maximum extent possible or appropriate, students with disabilities should be educated with their typical peers. Generally, least restrictive is in, wait a minute. Okay. Generally, that means in a general education classroom, but it is a continuum, and so we may see some students in resource rooms, which is more restrictive, but it is a continuum. The most restrictive is homebound, so there's a lot of stops in between a general education placement and homebound services. And so parents need to be aware of that. If the school's suggesting, you know, little Johnny's out of control, we can't manage him, he needs to go to homebound, you need to be having a discussion about placements that are less restrictive before we get there, if that makes sense. Okay. And then we also have to update the IEP and revise it at least once a year. Now, we can meet more often. A lot of parents aren't aware of that. They think they can only meet for the annual case review. We can reconvene that conference as often as we need to. On good years, we met 3 or 4 times. On bad years, we sometimes met more often. But if you as a parent have a question or a concern, you need to reconvene that case conference to have it addressed. Okay, I'm not seeing any questions so far. I'm not sure, Lana, how you, if we're just going to wait till the end.
Cathy, there is one question that I thought maybe you might want to answer now. And that was, how long do schools keep the records on file? Is there a requirement?
Put this over here. Sorry. Okay.
They have to keep them after a student exits school for a certain number of years. Right offhand, I can't remember exactly if it's 3 or 5. I think they will contact you to ask if you want a copy of those records after your child exits school, but I can't say for sure that that will happen. I know they did contact me. And so if your child is leaving school or anytime before, you can, of course, access the records. You can ask the school to make a copy of the records for you. However, they are allowed to charge a reasonable copying fee. And so whatever that might look like for you, for your school, you would want to find out. If a reasonable copying fee is 25 cents a page and there's 200 pages, you may want to be more selective. But hopefully you've got some of these, some of the documents at home anyway that the school would have shared with you. So, so bottom line, it just, you talk to your school and find out. Parents can request. Okay. Yes, but there may be associated copying fees. That is correct. Okay. All right, good. Okay. You should receive a notice if a case conference meeting is being scheduled, and it should tell you the date, time, and place of the meeting. And here's something that a lot of parents also are not aware of. It has to be at a mutually agreeable date and time, which means that if the school schedules it for Wednesday morning at 7 in the morning and you have to work and can't take off, you need to contact the teacher of record right away and let them know that you're not available. And then what I tell parents is offer 2 or 3 other dates and times. In fairness to schools, folks, these conferences are really challenging to put together. Sometimes they have a lot of people that they have to get at the table. What I always did was Wednesdays tended to be a good day for me. So I let my son's teacher of record know, please, let's schedule our meetings on Wednesdays, and we did. And of course, I also had other appointments that I would make, and sometimes we would have a conflict, and I would simply say, oh, that Wednesday doesn't work, or that time doesn't work. Could we make it later, or could we make it the following week? So, just try to make this as simple for everybody as possible. Let them know when you tend to be free, if at all possible. Okay, but again, mutually agreed upon, so it must work for you. I have had some schools tell parents that we only meet at 7 in the morning. Well, that may be their policy, but the law says mutually agreed upon, which means, no, it doesn't mean evening meetings. Unfortunately, we have to respect teachers' contracts, but there are even some schools that have expanded that, and teachers have been willing to hang around even after school to try to accommodate parents. So let's work together and try to, to help each other out. The notice of the meeting should also tell you the purpose of the meeting. Is this an annual case review, or is this an expulsion? We're looking at a manifestation determination meeting because of a disciplinary problem. So you should know ahead of time what the purpose of the meeting is. It should also tell you who's going to be attending, the names of those people and their positions, and which means that this is your invitation and you have the right to expect that those people will in fact be at your meeting because the school's telling you they will be. And it should also contain a statement that as a parent you can bring someone with you. Could be another family member, it could be somebody from Insource, it could just somebody that knows your child and can help you and can support you at your meeting. These are the
Cathy, this is Lana, and I'm sorry, but we're not able to hear you. I did have somebody type in that it appears maybe there are storms in your area, so maybe that is affecting your audio today, but we're not able to hear you. Okay, we can hear you now.
Okay. Okay, great, great. I'm on my phone again. I'm not quite sure why the audio keeps going out, but for some reason it does. Well, hopefully you've had a chance to study this chart. Obviously, we want the students there when we're talking about transition to adult life, because we're talking about what they want to do when they leave school. So they really should be there. We need a public agency representative. That could be the building principal. It could be
Cathy, this is Lana.
Yeah.
I'm sorry, we're not, if you've switched your slide, we're not able to see that.
No, I'm still on Who Must Be Invited.
Oh, okay. All right,
No.
I'm sorry. You had mentioned a chart, so I thought maybe there was an actual chart. I apologize for interrupting.
No, that's fine. Can you see the chart, Who Must Be Invited? Are you seeing that?
No, we're not seeing that.
So you are seeing participant.
It's still on the notice of the case conference meeting, what that notice must contain.
Okay. Because I have changed it and it's not, I don't know.
Okay. It does say on the menu. There we go. There you are.
Okay. I put it back. Okay. Oops. Okay, can you see Who Must Be Invited now?
Yes, we can.
Okay.
Okay, hang on. Okay. Can you hear me okay now?
Yes, we can.
Okay. I'm leaving my phone on, but I took it to a different room so it didn't give me feedback. So if the audio goes out again, I can grab my phone. And I apologize. I do not know why my audio keeps going out. Okay, I really do webinars quite a bit, just not quite sure what's up. Okay, but at any rate, the public agency representative should be that person that has the authority to pay for the services that we're writing into this child's IEP. So that could be the building principal, it could be somebody from the special ed cooperative, but you should know who that person is when you get that notice of meeting. And if you're not sure, you can ask at the meeting. We want parents there. Please, if you do not attend your meetings, the school will be making all decisions about your child. Even if you can't attend in person, you can attend by phone. You just really kind of need to try to be a part of it. By phone is not the best way to attend, but it's better than not being there. The teacher of record has to be at your meeting as well. The teacher of record is very, very important. This is the person that is responsible for helping to write the IEP, as well as for making sure that the IEP is being implemented by all of the teachers and other staff that work with your child. So this person needs to be there. If there's been an evaluation, then we need a multidisciplinary team member, and who also could serve as the instructional strategist, because that person has to explain the results of that most recent evaluation to us.
These other folks are required, or they're not required to be at the meeting, but they may be desirable depending on your child's age, and if they're transitioning out of First Steps, you want someone from a First Steps rep. You're looking to for your teenager to transition into adult life. We want somebody from a transition service, such as vocational rehabilitation, but those people are not required to be there, but we may want them, and the school has to have the parents' consent before they can be evaluated. Okay, I hope I just advanced my slide. I'm hoping you see it. Excusals, those people that are required to attend, they may be excused from attending if the parent and the school agree, and the parent has to sign consent to excuse them from not being there. People do get sick, things do happen, but the parent does have to agree. Now, if you wanted wanted that speech person there, the speech language pathologist, and she can't be there, but she was really critical to your discussion, then you may want to reconvene the meeting for a time when the speech language pathologist can come. So again, the school should let you know ahead of time if somebody is not going to
Cathy, it appears that maybe you're having some internet connection issues, and it may be helpful if I bring the presentation up on my end to help with that. Would you like for me to do that?
Okay, I'm calling in by phone again. I lost my audio. Are you seeing excusals?
No, we're not.
Okay, are you still back on the
there
chart?
We go. There's the excusals now. Yes.
Okay. Okay, great. Okay. So before the conference meeting, what are some of those things that we want to do? Okay. If you haven't started a notebook, you might want to, but in this day and age of emails, it's so much easier to email information back and forth. I encourage parents to create a file or a folder in their email account for and we want you to organize your home file. In the home file, many people do this already. I had a really good home file that was required to have one to know that I would like otherwise.
Cathy, we're having audio issues again. I do apologize for this. I know Cathy is probably a little frustrated as well, and she is very experienced in doing this. I just think it is some internet connection issues, I believe, probably.
It is definitely an internet connection. I'm not quite sure what's going on. Okay, so copies of all evaluations, copies of your child's IEPs, report cards, whether it's ISTEP or any other statewide and local assessments. It's really critical to have that information because that's how we can measure progress. That's how we can measure progress.
Okay. And homework samples. I found those to be very effective in making very effective in making the case for services. For example, for my son, he was required to make start taking notes in class, but because of his disability, he was unable to process the information quickly enough to create good notes. And so I asked the teacher of record, the actual teacher, of service, about getting some help for it, and they insisted that he needed to take notes. So I called a case conference and presented a sample of the chicken scratch, and the decision was, oh, when they actually saw what I was seeing, they understood this wasn't working. So we got pre-printed teacher's notes for each class, not just the social studies class. But my son had to highlight what the teacher was saying. So he was hearing, he was seeing, and he was actually physically engaged with that highlighter in the whole process. So I really thought that that was a win-win. But that's important. That's really important that you bring to the school to let them see what you are seeing at home, because sometimes they don't see that. They don't see it. And so, but at any rate, in your home file, everything chronologically arranged. We've got a lot of very common concerns that we hear from parents. I hear a lot, the school's not following the IEP, or they have an IEP and they're still not doing well. And of course, the favorite, I think my child needs more services. But what I tell parents is the concerns need to be based on evidence. So my first question is, why do you think they're not doing well? Well, poor grades, their homework is bad, they're failing ISTEP big time, the teacher's complaining, and so, it's really, this is valid information and things that you can bring to the table to share at your case conference meeting. Also, outside evaluations have to be considered by the school. Now, it doesn't mean that you're necessarily going to adopt those recommendations, but if you've had an outside evaluation by a psychologist or a neuropsychologist, you definitely want to bring that to the table with you. So I'm going to tell you Angela's story. Angela is my daughter, we'll say, and while I'm talking about her story, I want you to try to identify what concerns the parent is expressing, and then what evidence am I giving of that concern, and then how would I like to see this concern being addressed. Okay, so Angela, my daughter Angela, is in 3rd grade. She's always struggled with reading, but she's still mispronouncing words. So if I have her go back and read it again, she can usually self-correct. But I've made a tape recording of her reading when we read together, and she just does not read very well, and she's already in 3rd grade. The teacher has sent home notes expressing concern about her reading ability, and her reading scores are quite poor. I'm also concerned because she's so distracted. She forgets things. She's always forgetting to take pencils and papers to school. Her homework often doesn't come home. And I'm not quite sure what we can do about that. Okay, so in the handout, you're going to be getting this handout soon. We have what we call the Worksheet of Concerns. And when I talk to parents, what I tell them is, you need to fill this out. You'll also get a blank sheet, a blank worksheet of concerns to make copies of. But identify your concerns. You can see on my list here, my concern is Angela reads slowly. She confuses words when she's reading, and she mispronounces words when reading aloud. So the teacher noted it too. Obviously, the report cards are poor. So what would I, as a parent, like to see happen? Well, I'm not a teacher, but I'm thinking maybe she needs some extra help in reading, maybe some extra phonics assistance. And I brought that voice recording of her reading to the meeting so everybody could hear, not just the teacher. And so the agreement at our meeting was that the teacher is going to provide her with additional assistance while they're waiting to do a reading assessment, which is a great idea. And then you can see the organizational problems that we've addressed. She also has spelling problems. And what we agreed was that we're going to get her a homework planner. And that's going to go back and forth between the school and the parent. Now, folks, these agreements need to be written into your child's IEP. So what I try to tell parents is fill this form out ahead of time. Take it to the meeting with you. And then you'll remember to talk about these issues, and then you can record what the agreements are. In other words, what the school has agreed to do. But remember, if it's not written in the IEP, it didn't happen. So make sure that those agreements that you discussed show up in the IEP. Does that make sense? Does that make sense? I think this is one of the most important pieces of information that I share with my families. You've got to prepare ahead of time. If you write down your concerns before you go to a doctor, you need to write down your concerns before you go to a case conference. Lana, do we have any questions that have been posted?
Let me take a moment and I will look.
Okay.
Let's see. There are a few questions that you might want to answer right now. One question asks, how often are schools required to meet for the 504 plan?
How often are they required?
Mm-hmm.
Well, I don't, Section 504 of the Rehabilitation Act of 1973 does not specify, like it does for Article 7, special education rules, because they are considered two different entities, if you will. 504 is actually a civil rights law that prohibits discrimination against anyone of any age with a disability from being discriminated against. A reasonable time, I think the Office of Civil Rights would consider probably at least once a year, and certainly as a parent you can ask to meet more often. I can't, even though there's nothing outlined in Section 504 in the law itself that specifies that, I think that it would be considered to be reasonable. And certainly schools can kind of follow some of the arrangements that are set up in Article 7 for special ed and kind of put that in place for 504 as well. But there's no specific timeline, but there are some prohibitions against changing 504 plans without a re-evaluation. Okay? So if the school is looking to take your child off a 504 plan, they have to reevaluate your child first before they can do that. But yes, I would say at least once a year would be considered reasonable. And again, more often if the accommodations that you've written into the 504 plan are not working, or for some reason need to be adjusted, you guys should be meeting. And I guess I can take a moment. I don't know how many of you live up in Northwest Indiana, but on October 20th, I have an attorney from the Chicago Office of Civil Rights coming to Crown Point in Lake County, and she's going to do a 2-hour presentation on Section 504 in schools, and we're hoping that we'll get a lot of school folks and parents there as well. And so that the registration for that should be going out next week, so you can check our website under trainings if you're interested in registering to attend. It is free. But 504 is not very well understood by parents or by schools sometimes. So again, if you're dealing with 504 issues, this might be a great opportunity to really learn a lot about it. So sorry, I figured that was
perfect.
A great opportunity to promote that.
Absolutely.
Yeah, we don't get to have that happen very often, so I'm pretty excited about it.
Yes, I can imagine that does sound like a great opportunity and to get more information about that. Another question we have is, can an IEP be revisited by any teacher or only the teacher that authored it?
Well, the teacher doesn't offer it. It's when we revise an IEP, that's typically a case conference committee decision. Now, there is some provision in Article 7 that says for minor adjustments, the parent and the teacher of record can talk about it and agree to it, and the teacher of record has to rewrite the IEP or add that piece, whatever, to it, make copies and distribute it to everyone. There should never be anybody at school making a unilateral decision, that means on their own, to make some sort of change to a child's IEP. They are not allowed by law to do that. That has to be, you know, for the bigger changes, it's the whole case conference committee that sits down and decides. But for smaller ones, like for instance, you know, maybe as a parent I'm saying, you know, I think Johnny would do better if he was sitting right by the teacher because he has ADHD. I could call the teacher of record and say, you know, I think that could be useful. That's small enough that the teacher of record and the parent could make that change. But again, the process is the teacher of record then has to enter that into the IEP, revise that part of it, make copies for everybody to make sure that, you know, everyone that works with him allows that preferential seating. But if a teacher is saying, you know, I think this child needs to be in a self-contained classroom, this resource room isn't working, that's a really big decision. And that you have to convene your case conference meeting. Does that make sense?
Okay. It does make sense. Thank you. Let's see, a lot of information trying to help us with the issues such as the internet issues up north. So it looks like we can probably hold some of the other questions for a little later if you would like to go on with the presentation.
Sure. Gotcha. Okay, so final preparations. Again, you've been notified about the meeting. Make sure the date and time works. Reschedule if necessary. Ask how much time is allotted for the meeting. Some schools will only schedule, you know, half an hour, 45 minutes, maybe an hour for a meeting. If you've got a lot of big significant issues, you may need to ask for more time. If they say we can only give you an hour, because what I frequently see or hear happening is the meeting's been scheduled for an hour, you're from 9 to 10, the next meeting starts at 10 for another family. We get to 9:55 and the school's wrapping up because we've got another meeting. The parent thinks that the discussion is over. Okay, well, I guess this is just how it's going to be. Well, if you agree with everything, that's wonderful, but what happens if you still have more questions that haven't been answered? Or what if you need more discussion about a particular issue? It is okay to say, I think we need to meet again to continue this discussion, and then try to set up a meeting for maybe the following week. So in other words, it doesn't have to end at 9:55 just because there's another meeting scheduled. If your questions have not been answered, if your concerns have not been addressed, then ask to meet again and maybe ask to schedule for a longer period of time. Generally, you kind of have a feel for that. Some meetings are very, you know, relatively uninvolved, if you know what I mean. Some have a lot of issues that are at stake and may need more time. You don't have to tell the school if you're bringing someone, but since the school tells us who's going to be who they're bringing, I consider it just kind of an act of courtesy to let them know if you're bringing someone from Insource or another family member. You're not required to, but just again in the interests of consideration and good relationships. You may want to practice what you want to say in advance, especially if it's something really hard that you need to say. Some schools will write a draft IEP in advance of the meeting. Often we usually get those right at the meeting, but it is only a draft, and we understand we're going to be discussing it. But ideally, it would be wonderful if we could get that even before we got to the meeting, but generally that doesn't happen. It's kind of nice to see what the school's proposing. And then bring that worksheet of concerns with you. Bring that with you, because I don't know how it is for most of you, but I would go to my meetings knowing what I wanted to talk about, and then I'd be driving home and I'd realize, oh no, I didn't talk about this or I didn't talk about that. So having those issues identified on paper in front of you helps you to stay on task or on target and helps you to go through your list to make sure that your questions and concerns are being discussed and hopefully answered. So really, really important. During the meeting, and again, I can't stress this enough, you're not a student, parents. In this meeting, you are an equal member. You are an expert on your child, and you bring important information to the table that that the whole team needs to hear. And so just, you're a part of the team. You shake your hands, watch your body language. Try not to roll your eyes if you're not happy with something someone said, because other people do see that and they interpret that usually appropriately. And again, establish how long the meeting is expected to last. If it's going unexpectedly long and people have to leave, please, please ask to reconvene that meeting. Okay, this one gets a little trickier. For the very, very first individualized education plan that's being written, that means your child has been evaluated for the very first time. Some of you may be in that boat. You and the school are going to sit down, you've determined eligibility, and now we're writing the IEP. The school, whatever services you all have agreed that this child needs, they cannot be provided by the school until you, the parent, sign consent. Okay? What happens if you disagree with what the school is proposing? Well, then you're probably not going to sign the IEP. You're going to challenge it, and we'll talk about what that might look like. You need to understand there are no services until you guys have an agreed upon and signed initial IEP. But what if this is a subsequent IEP meeting? Your child's had an IEP for a while. Well, you're going to sit down and try to write up this IEP with the school. The school has 10 business days to get you a written copy of what you all discussed at your meeting. You then have 10 instructional days to review it, what was written, make sure it matches what you remember of your discussion with the school, right? Hopefully you were taking notes. And if it matches what you remember, sign it. They'll ask you to sign just to show that you did consent, or you are in agreement, I should say. Go ahead and sign it and send it back, and it'll be implemented. But what if you and the school have some significant disagreements? Well, then you parents need to notify the school, preferably in writing, that you disagree, what you disagree about, and what you would like to do to try to work through those disagreements. In that case, since there is already an IEP in place, the current one remains in place until the parents and the schools can come to an agreement for a new one. But it's important that if you disagree, that you challenge it, because if you do nothing, if you say nothing, that 11th instructional day after you've received a hard copy, that proposed IEP goes into effect whether you agreed with it or not. So you've got to say something if you disagree. Okay, so part of finalizing the IEP, again, for the very first IEP, you have to sign it before school services can be provided, and they will then be implemented no later than 10 school days after the parent has signed the first IEP. Usually they'll implement them sooner, but they have up to 10 school days. What about the revised IEP? Again, subsequent IEPs do not require a signature, and so they will be implemented on the 11th day after the parent receives their hard copy of the proposed IEP, unless you all agree to implement earlier, and you certainly can do so. Or, of course, if you challenge it because you don't agree with some aspects of it. So I know that's kind of confusing, but we do try to separate that out. So ways that we can challenge that proposed IEP, I encourage people to start at the case conference level. And so, we've had our meeting, and usually at that case conference meeting if there are issues of concern. You've been meeting for an hour already, and it's okay to say, you know what, I think I'm not in agreement with you on how many minutes of speech Johnny should have or how many minutes of physical therapy. I would like to convene again reconvene and to discuss this further. Then that gives you time to collect more data or whatever else you think you can bring to try to change the school's mind about their proposal. So you can certainly try to meet again. You could agree to implement the IEP as written, but you can offer what's called a written opinion. And basically you're going to note what your concerns are about this IEP, what it was exactly that you weren't in agreement with. And we'll see this happen when it's really critical that we get those services up and going quickly, so the parent doesn't want to delay the implementation of an IEP, but yet there were certain pieces of it that they really weren't in agreement with or had concerns about. You can write that written opinion. It goes into your child's file. In our district, it usually goes before the special education director, and she would sometimes contact parents and kind of discuss it further, and sometimes some changes could be made. So, and then of course your other option is to pursue mediation with the school. The school has to agree to it, or to go to what's called a due process hearing, and I'll talk about that more in a minute. It's really important that we try to establish a good working relationship with the school. Our kids are going to be in school for at least 13 years, and having a good relationship with the school doesn't mean that we just say, okay, whatever you want. That's not how relationships work. We can still have good relationships and still disagree from time to time. But we do know that kids tend to have better outcomes when parents and schools work together. I didn't always agree with the school, nor did the school always agree with me, but we had a good enough working relationship that generally we were able to work through our issues, and sometimes the school would compromise and sometimes I would compromise. But the main thing was that nothing was being compromised in terms of the support that my child got. So I really feel like it was a win-win situation for everyone. And then, of course, the law does provide for more formal options when the issues of disagreement are very significant. So let's talk a little bit about those. Sometimes schools do not implement the IEP as written, or they may fail to meet one of the timelines that are outlined in Article 7, or they may fail to do something else that Article 7 requires them to do. And if that's the case, parents have the right to file a complaint. And basically that's considered to be a violation of law by the school, and that complaint is sent, you would send that to the school and to the Department of Education, and the DOE can investigate it, and then they can either fine for the parent or they can fine for the school, depending on the evidence that's presented. But if something's not happening that should be, according to law, parents can file a complaint. But I just want to put it out there. I do encourage parents to talk to the teacher of record first to see if you can't get it taken care of, again, at the building level. Once you start filing complaints, it can make your relationship a little more challenging with the school. I would never tell someone not to file a complaint. That's not my place. But see if you can't work it out at the building level first. If you can't, then a complaint is absolutely something that you would probably need to consider doing. Mediation and due process hearings are a little bit different. Those are for what we call disagreements of opinion, if you will. For instance, I mentioned how many minutes of speech or physical therapy. There's nothing in Article 7 that says a child that requires physical therapy is entitled to 30 minutes of therapy a week. It doesn't say that. Article 7 expects that the case conference committee will know enough about a child to determine what those services need to look like and how much and how long. And so what happens when the school says this many minutes and the parent says this many minutes, and if you guys really are far apart and you really can't come together and it's just really something that's that you as a parent feel is very critical, then you may need to ask the school to mediate the issue with you. The school does have to agree to mediate. A form gets filled out, it gets sent downstate, and then the Department of Ed would assign a mediator at no expense to come and to help to the mediator will try to help both sides to resolve their disagreements. But again, the school does have to agree to that. You can also or simultaneously file for a due process hearing. This is a much, much, much bigger step because it involves attorneys. The school will have an attorney representing them. As a parent, you can represent yourself if you choose, but you can hire an attorney as well. And understand this will be, it's a much more formal process before a hearing officer who basically serves as a judge, and he's not mediating. He's going to decide based on the evidence presented which side is right. And so, you know, those are for those really big issues, and sometimes parents do need to go to a due process hearing, but just be aware it's a very, very big process, and I would strongly encourage you to learn as much about the process as you can before you take that step, because it's a very, very significant step and a costly step as well. Something new that's come up, and this is not in your handout because I just added it yesterday. There is we can go to iChamp at the Department of Ed's website, and it allows us to electronically file a complaint or file for mediation or for a due process hearing. It used to be you could fill the form out online, but you'd have to print it off and sign it and then physically mail it in. Apparently this is going to bypass that, though I have been told that there have been some glitches in it. It's pretty new, so don't get too excited just yet. We may need to let them dust it off a little and do some tweaking, but the whole process is, the whole idea is to try to simplify the process for parents and to make things go faster. So keep iChamp in mind, and you can always go to the DOE website and check that out as well. But again, just remember, it's got some glitches that they're trying to work through, but I thought that was pretty interesting. Okay, you can always go to insource.org for more information. There's that contact information, all of those online trainings. I think I mentioned we've done a video on this particular presentation. It's a lot more exciting to see people talking than it is to hear them, I think, sometimes, but you might want to go to our website and watch that. You can also go and see the calendar of all of the trainings that we're offering around the state and see what's near you. And you'll also see that Section 504 presentation that I'm really excited about in October, and hopefully soon you'll have the opportunity to register if you can come up for that. Okay, and then this is my name and my information if you'd like to email me, but we do have some time for questions. And again, I apologize for the technical issues. I am not quite sure what happened, but if you've got some questions, I would certainly like to hear them. Lana, are there any questions?
Cathy, thank you very much. Yes, we do have some questions, so we'll take a few minutes to answer those. And as I mentioned before, if there are any that we're not able to answer today, because we do want to be aware of the time factor, we will attempt to answer them and include them on the question and answer document that will be sent along with Cathy's presentation today and the handouts she mentioned. They will also be available, all of those, on our website, on IPMG's website. Again, give us a couple days to get that information together, but it will be on there very shortly. Okay, Cathy, a question asking if you find that schools discuss other services like VR and waiver services during IEP meetings, and is this a requirement? as a case manager, this person has been told by some parents that they were told about the waiver from other parents rather than the school. So I think what they're asking is the school required to discuss other available services such as VR or Medicaid waiver services during those peace conferences or meetings.
I don't know that the schools are required to discuss Medicaid waiver because technically it's not a school-related issue, but for VR, because during transition IEP meetings when the child is in high school or going into high school, yes, there definitely should be discussions about that because you need to have that discussion. What other services might be out there for me when I'm looking to leave school that will support me in either furthering my education or perhaps helping me to get a job, which is what VR is all about. So yeah, there should definitely be discussions about voc rehab. What I find is that in talking with school staff, and I've spoken with many throughout the state, I believe they do give information out, but for some reason I don't know if parents aren't, if they're getting written documents and they're not reading it, or if it's actually not being talked about during the meeting. It should be. And it's a shame because those are good discussions that need to be had. Voc Rehab provides wonderful services for kids that qualify, and as far as med waiver goes, yeah, that one's challenging. I know some schools do try to provide that information to parents because they know that these kids are going to need it, but to my knowledge, there's no requirement in the law to discuss med waiver any more than there is to discuss applying for insurance or or anything else like that. So, but yeah, most of the time, very often parents find out about med waivers from other providers or from other parents, like you said, and yeah, it's just really challenging to get the word out sometimes to parents.
Right. I will say that the Division of Disability and Rehabilitative Services, or DDARS, was working on an initiative to provide additional education to school corporations regarding Medicaid waiver services. And I know IPMG, along with other case management organizations, are also trying to work in partnership with schools to provide that information to parents at a young age of their students so that they can begin to apply for those additional services outside of the school setting, so which is exciting. What would you suggest, Cathy, if a parent reaches out to a local Insource office and feels as though those services are not able to be provided right away, maybe because the office is busy? Is there, should they contact the main Insource number, or if they need additional support, then maybe what they feel like they're getting from their local office?
Yeah, that's always a challenge because those of us that are regional staff, like myself, we only work part-time and we cover multiple counties. And so, there really are some very real, unfortunately, time restraints, and trying to, to get back to everybody. We really work hard on getting calls returned as quickly as possible. And yes, you can certainly always call the main office and talk to staff there if there's someone available, to get questions answered, especially if you need an immediate response. Sometimes there are some critical things that come up. Most of the time there is time, and so if you don't get a call back for a couple of days. But I think that I'd like to take a moment to kind of go back and talk about exactly what it is that Insource does. Parents tend to think that we're there to serve, that we provide advocacy services, kind of like an attorney would. We actually advocate for the process. We're a parent training and information center, which means we train parents on the special education law so that they understand the process better, and we provide information, you know, depending on what the needs of the parent is, again, generally with the view to trying to help that parent, educate that parent to become a better advocate for themselves, because we can't go to everybody's case conferences. We simply can't. And so being a parent training and information center, our focus is to make sure that parents have access to information that they need about the process. And you know, when the more educated you are, the better you're going to be able to advocate for your child. When you don't know what the rules are, you don't know if they're being broken. And so we like to, you know, kind of think of it as, you know, we're educating you about what these rules are that everybody has to follow, and trying to keep everybody honest, I guess, for lack of a better way to say that. So again, we're an educational agency. We educate parents, we train parents, and you know, we all do our best to support parents in any way that we can. But like I said, most of us are part-time, and we cover multiple counties, and I know it sounds like kind of a, you know, not a great excuse, but the reality of it is we have time constraints, and I do know that sometimes parents do want more from us. They do want us to serve more, kind of like an attorney would do, going into a meeting and, you know, just doing what an attorney might do. And we really can't do that. We really can't. But it doesn't mean that I won't support you. I can coach you from the sidelines, but I can't get on the field and run the ball down, if you know what I mean.
Absolutely. And I think that's very good educational information for those that are on the call or on the training today, to kind of understand a little better what Insource role is and all of the resources that you have available through your website for education and training. So thank you for that. I have a couple of questions that are a little more specific, maybe to a situation, but basically I do think you covered this, but if a parent or a family is concerned about issues that their child is having in class, they do have the right, and correct me if I'm wrong, Cathy, to request an evaluation through the school. And then I believe you discussed what that process is. Once that request has been made, then the school has what the school's responsibility is. Then a couple questions were related to, you know, if a child has ADHD and sensory issues and they're struggling, but the school is reluctant to discuss special education. And then also another question asking if a student, or excuse me, a school is wanting a student to attend half days due to behaviors, what options there are. So maybe if you could just kind of review in general what those types of options are for parents in those situations.
Okay, so in 10 words or less, no.
Right.
Yeah, regarding a referral for an evaluation, you know, there are a number of reasons why kids don't do well in school, and not all of them are related to having a disability. They're just not. Just kind of putting that out there on the table, and Article 7 recognizes that. But, you know, if a parent really does have concerns about their child's performance, especially if it's been ongoing, you know, kids have bad years sometimes, or bad semesters, you know, maybe because the coursework was harder than they were used to, or whatever. But, you know, if you're seeing that pattern, especially if your child has already gotten some type of diagnosis, maybe a medical diagnosis or even a psychological diagnosis, you know that they already have been diagnosed with a disability of some sort. If that is rolling over into the school setting and possibly interfering with their ability to learn, that really does need to be looked at. So what I tell parents to do is, in writing, please, in writing, you know, shoot an email, whatever, keep a copy, but to the building principal. You could send one to the special education director as well if you have his or her email address, and just express your concern. You know, my son has been failing math for the last 3 years, and nothing seems to be working. I believe that he needs to be evaluated for special education services. And then sincerely, you know, your name, and date it and send it off. That's when the school has those 10 school days and they have those 10 school days because they're going to review your child's records. They're going to look through it from, the beginning up till now. Is there some sort of pattern that emerges? Does it, has the child significantly struggled in these areas? What are some of those reports? And then based on that, the school has to decide, is there enough information here to suggest that maybe there is something going on here. And if the school believes that there may be, then they are going to respond to the parent in writing, yes, we're going to evaluate Johnny for whatever, they'll tell you, and then they need your written consent. So that's what you need to hop on right away, because once the school receives your written consent to evaluate, which is different than the referral, they have 50 school days in which to complete the evaluation and to convene your case conference to determine if little Johnny is in fact eligible for special education. One problem that we've had over the years is schools saying when a parent makes a request for an evaluation, well, we want to do RTI, or response to intervention. And response to intervention can be remarkably effective if it's done well, if it's done appropriately. But what I keep hearing is they've been doing RTI. These are specific interventions for this child in the classroom. But I've heard situations where they've been doing RTI for this child for 2 or 3 years, and the child is still struggling. Well, clearly that's way too much. The school can't refuse to evaluate a student by saying he has to do RTI first. That's not an appropriate reason to refuse to evaluate. Now, if the school genuinely does not feel this child might have a disability, they can say that and they can refuse. And the parent can mediate that or go to a due process hearing if they choose to, if that's what the school says. But RTI can't be used or insisted upon being done first prior to allowing a special education evaluation. So just kind of keep that in mind. Probably more information than you wanted to know, but all you can do is try, and then based on the written response that you get from the school, yes or no, if the answer is no, you may want to call Insource and we can maybe talk through it. They're going to have to tell you the basis for their refusal. Okay, you also, what were some of the other things you mentioned?
I mentioned, and I think you did discuss this, kind of the least restrictive has to be looked at first, and if the school is suggesting or recommending more restrictive, kind of what the options are for parents in that situation.
Yeah, that's a tough one, because very often what schools will tell parents is, if he keeps having these meltdowns, we're going to have to start calling the police, and certainly that is the right of the school, because we know safety comes first, or we're going to have to start suspending him. And what parent wants their child suspended, right? I haven't met one yet, and so sometimes we will just go ahead and agree to that. I can't say across the board that a partial day placement is always inappropriate, because it's not. For some kids, that's the upper limit of what they can tolerate because of sensory issues or, a number of issues. But the whole deal is we need to be then working on how do we get little Johnny, how do we increase his day so that he can get back to being in school for a full day. And so, again, I just want to be clear. I'm not going to say that going a partial day is always wrong, but it makes me a little nervous that that's become kind of the default response. What a parent needs to do is convene that case conference meeting and say, maybe we need to revise the behavioral intervention plan. Because what I see and what a lot of us see is we've got these behavior plans, there's nothing positive about them, which they're supposed to be. They're all punitive. They tend to be pretty punitive, and we keep using that behavior plan, and the behaviors keep manifesting. They keep happening over and over. At what point do you say, maybe this plan isn't working? At what point do you say, maybe we need to revisit that behavior plan and make some changes so that maybe we can bring about some changes in little Johnny's behavior so that he can be appropriate and stay in school all day. I like to talk about Einstein's definition of insanity, doing the same thing over and over and expecting a different result. If your child is continuously getting in trouble, and if they don't have a behavior plan, you need to be asking for a functional behavioral assessment, first of all. And then you need to develop a behavior plan. But if your child has a behavior plan and it's been in place and little Johnny keeps on keeping on with the behavior challenges, you need to go back and revisit that behavior plan because something needs to be adjusted. Does that make sense? Something
yes,
needs to
it
be
does. Yes,
yeah.
That makes perfect sense.
Yeah.
Thank you. We do have a couple questions. If you could just tell everyone again, or maybe move back to that slide, the Insource website address. There we go. So everyone, I'm also going, this information again will be provided, but that is up for everyone to see. And I do believe you said, Cathy, that the training in October on 504 plans, that is actually an in-person training, correct?
Yeah, well, yeah, we're sponsoring it. We're sponsoring it.
Right.
Yeah, I asked them to
but
come
it
down.
is in person. It's not going to be available to attend online, right? It is actually in, okay.
Yeah, and we're not allowed to record it either, so even if I had the capabilities,
right.
But no, it's
because you're having,
yeah.
Let's see. I think we have time for one quick question, one last question. And this is asking how an IEP can follow someone to college, and I don't know about that, but maybe you could provide us a little bit of information if you have any on IEPs following students to college.
Well, IEPs do not follow students to college. They are only for public schools, the 3 through 21, more or less, and so, or until you leave school, I should say. So if you're looking to go to college, the student needs to share with the college that they're looking to go to that they had an IEP in school, that they had they've got a disability, and depending on which school you go to, they're probably going to ask to see a copy of the most recent IEP. They may ask for, I don't even know what all they might ask for, but basically the student has to advocate for 504 protection, because at that point Section 504 kind of kicks in. And so remember, it's an anti-discrimination law for any person of any age. So it would allow that young person going to college to get some additional resources or supports, if you will, but it will not be like your IEP. They expect you to, to go to the proper office to let them know that what supports you might need, whether it's having, textbooks read aloud and recorded, whether it's note-taking, and then that's between you and the student and the school, what those resources might look like. So, and hopefully before they leave high school, their teacher or guidance counselor will be able to, provide some additional information about what that might look like. But Insource does have we call it a college survey, and if you go to our website, you can find it there. It talks about the various colleges and universities in Indiana and what what sort of supports and services they offer to their students with disabilities. So basically, we need to develop some self-advocacy skills for our young people, because they're the ones that are going to need to go to these special offices, to advocate for themselves, to say, look, I have a disability and I need these supports. So look for a school that offers the kind of supports that, work best for that young person. So
absolutely. Well, thank you for that. That was very good information. One last quick question is, someone is asking, what RTI stands for. So I think you had mentioned RTI. I think they just want to know what that stands for.
Sure, it's response to intervention, and basically it's all around. I mentioned earlier, not all kids that struggle in school necessarily have disabilities. Sometimes kids just need some, maybe take longer to learn how to read just because, or just need some sort of specific targeted interventions. And so once a student, basically if you can think of a pyramid, on the very bottom layer are 80% of our students. They learn very well in a regular classroom, regular instruction, but about 20% of those kids are going to struggle, and so we put them maybe up in the next tier, and then we're going to start doing specific interventions for those kids to try to catch them up to the peers on the bottom, if you understand what I mean. Maybe they get a little more reading time, a little more one-on-one for math, whatever those issues are, but they have to be scientifically research-based interventions that are proven to be effective. And then most of those kids will do quite well with that and hopefully catch up with their, with the other peers. But then there's a small percentage that even with those interventions, it's still not working, and we may do even more targeted and intensive interventions typically in the classroom. And if that doesn't work, that child definitely needs to be referred for a special education evaluation. And so that's kind of it in a nutshell, but schools do RTI, and I would encourage you to have a discussion with your teacher, what that looks like in your particular building. And so, does that make sense?
It does. Thank you so much. Well, I am going to reiterate many of the comments here, which is to thank you very much for the very informative presentation. And I think it's going to be very helpful for parents as well for those of us that are helping to support parents and students as they go through the school process. So thank you so much, Cathy, for taking your time today to share this with us. Please, everyone, visit the Insource website, especially if you're looking for additional training or resources or information. And again, this information will be available within the next 2 business days on our website, IPMG's website, and we will also send this out to all those that registered with the link to the recording as well as the materials and the handouts that Cathy has provided to share with everyone. So thank you, Cathy, and thank you, everyone, for participating and being patient with us as we work through some of those technological issues we were having. Have a great rest of your day and a great weekend. Thank you.
Thank you so much for inviting me.